welcome everyone. Thank you for joining us for our free seminar today entitled Enforcing Your EEO Rights in the Federal Workplace. And so what we're hoping to do today is give you sort of a on-the-ground, both theory and practice approach to the EEO process. Because I know that it can be daunting when you're approaching the idea of whether or not to file an EEO complaint. And what we're hoping to do is arm you with some basic tools to guide you through that process, and also to show you some of the benefits of representative or having an attorney with you to sort of guide you through that journey. My name is Peter Mina. I'm a senior associate here at Tully Rinckey, and my practice centers around federal personnel and employment law. I cover federal employment matters ranging from EEO complaints to whistleblower issues, and I also represent people in disciplinary actions before federal agencies as well as the Merit Systems Protection Board. To my right is my colleague Rachelle Young. She's an associate here who also practices in federal sector employment law. She represents clients across the federal government as well in EEO claims as well as wrongful termination and retaliation claims. So what are you going to learn today? What are you going to get out of today's seminar? The first is you're going to learn what specific protections you have in the federal workplace under the anti-discrimination statutes that cover federal sector employees. Next, you're going to learn, okay, now I feel like I've been discriminated against. What do I do? Next, we're going to talk about what some of the important deadlines are. And deadlines are, as you will learn, are critical. It is the easiest way an agency is going to try and knock out your complaint is by missing a deadline. And it's the easiest thing to monitor, you can control. Next, we're going to talk about what to expect during the informal and formal complaint processes. We'll break each of those down, give you some tips, and tell you what you need to know about those processes so you're not going to be surprised, and also why having representation through that process is going to be beneficial for you. And then last, and I know I've touched on it, but we'll also talk about some of the specific benefits an attorney can provide as they represent you through the EEO process. At this point, I'll turn it over to Rachel to talk about some of the bases of protected against.
Sure. So in order to talk about enforcing your rights, it makes sense to start off with being sure that you know the types of discrimination that you are protected against in the EEO process. Now, one of the things that I think Peter and I have seen in our practice is that at times people feel that they are protected against all types of discrimination.
Absolutely.
Whereas in federal employees' practice, their rights to complain of discrimination arise from a number of statutes that provide very specific rights and very specific protections against discrimination claims. Now, those types of discrimination include allegations on the basis of sex or gender. You're protected from discrimination on the basis of your race or your color or your origin in terms of the country that you're from, or even including ancestry or ethnic characteristics that pertain to you based on employees over the age of 40 are also protected on the basis of age discrimination. That includes employees who are 40 and over. In addition, other bases for claiming discrimination include the basis of disability, as well as genetic information, as religion. Now, the statutes provide for broad coverage under these different types of discrimination. So, for instance, discrimination laws or anti-discrimination laws are not applicable just to, let's say, minorities or to females. They apply to everyone who falls into one of these protected categories. For example, a male employee who's working in a, let's say, a predominantly female-dominated work environment, or a female occupation, might find that he's being discriminated on the basis of his gender because he's passed over for promotion, whereas people that are less qualified for him, that are women, are selected. So that employee would have a right to pursue discrimination under a sex discrimination claim.
I think that broad coverage you also see in an area like disability, where particularly given the new amendments to the Americans with Disabilities Act, There's coverage for, even if not necessarily you're disabled yourself, but if you are associated with someone who's disabled, or if your agency perceives you to be disabled. For example, they think you have a condition that limits your ability to do certain physical demands of your position, or to, complete a certain task. That can be a basis of discrimination. And then, as Rachel touched on, genetic information is a new category. So, for example, if you had to provide genetic data that revealed that you were predisposed for a certain condition or disease, and you were discriminated against because of that, you now have a right to file an EEO complaint.
And just along the lines of broad construction, for instance, national origin is another example, whereas it may be obvious that that applies to someone who is foreign-born, who moves to the United States and seeks employment here, but it also might apply to U.S.-born citizens, such as someone who is born in Puerto Rico. On the basis of their ancestry or ethnic characteristics, they may have a claim for national origin discrimination. So in this process, given that broad nature, you may be able to claim discrimination on the basis of a number of different issues that affect or pertain to you. So moving forward, now that you understand the types of discrimination that you are protected against, I want to give you an idea of the types of reasons that you can assert in the EEO process for showing that you believe that you've been discriminated against. Now, there are some legalese that we use in our practice, and we'll try to explain them to you.
Comes with the degree, unfortunately.
Unfortunately, it does. And one of probably the most common forms that people allege in filing discrimination claims relate to claims of intentional discrimination, or what we term as disparate treatment. And what that essentially means is that you as a federal employee may find that you are being treated differently than people who are similarly situated to you. And, of course, I shouldn't explain what the term similarly situated means.
Exactly.
And that might mean, again, this can be broad, but, most commonly it might be a coworker of yours, someone who performs duties that are similar in nature to what you do. And that reports to the same supervisor. And by taking that person as you find that you are being treated differently in the course of your employment than that other person, and you believe that it's due to one of the protected characteristics that we discussed, either age or race, etc.
I think one of the important things to know about disparate treatment is, there are a lot of reasons why people are treated differently. Some of them afford you legal rights, like under the EEO process, and some of them don't. And we'll talk about some of the ones that don't, but I think it's important to realize when you're looking at whether or not it makes sense to file an EEO complaint, think about whether it fits, whether the difference in treatment fits into one of these categories that we've talked about, like sex or race or age or national origin, when you're looking at whether or not you may have been subjected to disparate treatment.
Mm-hmm. So that's one of the more common forms that people allege in pursuing their EEO complaints. One of the less common ones does not relate to discrimination that is necessarily intentional. And it could be based in some sort of genesis of some sort of policy implemented in your workplace that seems to be neutral on its face, meaning that it does not single out on its face or in the language of the policy any particular protected characteristics such as race or national origin, etc. But this claim really lies in the fact that that neutral policy, when applied to a particular group of people, has an adverse or negative effect on that protected group, and this can be statistically shown. So, for example, a policy that might deal with restrictions on height and weight, that might negatively impact a particular group of people who are applying for a position with the federal government.
Absolutely, and I think kind of similarly, one of the types of cases you see in disparate impact has to do with pre-employment testing or promotion testing. For example, if there's a basic exam to become a firefighter or a law enforcement officer, and that test affects a certain group disproportionately, then that group of people might have a disparate impact claim.
One of the more common forms that we see a lot in our ordinary practice relates to claims of hostile work environment harassment. And employees that find themselves subjected to a hostile work environment may find that over the course of either a number of days or months or years, they find that there are a series of actions that are taken against them that constitute altogether an unlawful employment practice. Now, in thinking about this, the concept behind a hostile work environment claim is not that it's a series of just independent types of incidents that occur that are unrelated. Your goal in trying to establish a hostile work environment claim is to show some sort of common connection or some sort of common thread between the harassment that you're suffering. For instance, maybe it's perpetrated against you by the same supervisor. That's a very easy way of establishing hostile work environment harassment. So an example of this might be an employee who over the course of, let's say, a 12-month period finds that his manager is repeatedly using racial epithets against him, denying him training, accusing him of misconduct. And if he is able to weave those claims together, that can form the foundation for a hostile work environment claim.
And I think one of the reasons why we see this, quite frankly, more frequently is because a lot of people, and I hear this phrase all the time, and I'll talk about it a little bit later in terms of the filing process, when the first thing happens, they give their agency the benefit of the doubt. Or they think, okay, this is an isolated incident, it's not going to happen again. I'll just let it slide. But, the next thing happens, and the next thing happens, and the next thing happens, and it's a year later, and you've got this whole series of events. And that series of events, it may constitute a hostile work environment. So now that we've talked about the EEO process and the kinds of discrimination that you might face, let's jump ahead a little bit in terms of another basis of protections that actually looks at activity after you file the complaint or after you participate in opposing discrimination, and that's retaliation. And this occurs when an agency takes an action against you based on your participation in protected activity. And there are really two ways that you can participate in that protected activity that would trigger protection from retaliation. The first is called participation. And what that could mean is filing a charge of discrimination, testifying in someone else's complaint. So it's not just if you file the complaint. If your coworker files an EEO complaint and you're contacted by an investigator to provide a statement, for example, that in itself is protected activity. The other form of participation is, or actually the protection, is opposition. So it doesn't even have to be in the form of an actual EEO complaint. It could be, for example, you're in a meeting with your supervisor, and he or she is informing you of a non-selection, or maybe it's a bad performance appraisal. And you say, Mr. Jones, I think that you're treating me differently, or that you're downgrading me, or that I wasn't selected because of my race or my gender or my national origin. So it doesn't even, there are no magic words here. You just have to express to your supervisor or whoever is making the decision, hey, I think I'm being treated differently. And that may be what's considered opposition of a particular employment practice.
And I think, Peter, in terms of just our practice, a lot of times, because, as an employee, you have an uphill battle in proving your claims based on discrimination. It's your duty to establish that you believe that those actions are taken against you because of your status in a protected group. So when it comes to retaliation claims, I think we often find that it's sometimes easier to prove retaliation than it is to prove discrimination.
Oh, absolutely. Because the important thing to know is that you could have a claim